Good morning. This is House Ways and Means Committee, and it's March 11th, 2026. We're going to start with the absence of Chair Coinheiser. And so we're going to hear on H 757, act relating to manufactured homes and limited equity cooperatives. Cameron Wood.
No technical issues to start out this time. Fingers crossed. See what happens. Good morning. For the record, Cameron Wood, Office of Legislative Counsel. I'm going to walk through a proposed amendment to H 757, drafted as an amendment from this committee. Give me 1 second. I'll share my screen and we'll get going.
It's out of control. You're sampling the meth.
We know it all is good.
Okay. So what we have here is a draft amendment from this committee regarding 757, an act related to manufactured homes and limited equity cooperatives. This is a bill that was in House General, came out of House General with a recommendation from that committee to amend the bill as introduced, came to this committee. So this amendment is drafted as a strike law because there were a few changes kind of throughout and deletion of one section later on. So it was just easier to draft it as a strike law as opposed to instances of amendments. So jumping right in, we have under section 1, manufactured homes. This is the same section that was in the bill and the proposal of amendment coming out of the House General Committee. So kind of moving through to page 2. The first thing we have here, if you all recall the bill as it was recommended from House General, was making this slight tweak to the definition of permanently cited. This remains the same, so there was no change based on this proposed recommendation here. Permanently cited, the language there on line 5 is just intended to clarify that when defining permanently cited, all of these subdivisions aren't required to be met. So it's one or more of the following. But that more, kind of clarification language remains the same as it was proposed by House General. Moving into section 2604, real estate deeds. I'm going to look at page 3 is kind of where I'm going to start here. What this section does is in A and B, it's saying that current law, it's saying that if you purchase a mobile home from a mobile home dealer, that's I'm on line 16 and 17 there. If you purchase the mobile home from the mobile home dealer after July 2008 and it's financed as residential real estate, then it shall be conveyed via warranty deed. And if you all recall, when we discussed this initially, there's a separate section that says if the home is going to be permanently sited on land that the individual owns, it shall be financed as real estate. And if it's going on land that the individual does not own, so it could be going into a manufactured home park, for example, then it may be financed as residential real estate. It's not required, it's a permissive. So if it's not financed as real estate, what is it financed as? Generally speaking, could be financed as just a, kind of a personal property loan, could be financed under some sort of retail installment contract if you're purchasing it from the dealer, etc. So more personal property loan versus a residential loan. So what this section says is if you're buying it from the dealer and you're financing it as residential real estate, it has to be conveyed via deed. And that's been the case since 2008. The subsection B is saying that if the owner is financing it or refinancing it as real estate, or if the purchaser is financing the mobile home as real estate, then it shall be conveyed via deed. So if I own the mobile home or manufactured home that, I bought many years ago via a bill of sale, and then I'm going to sell it to someone else, maybe I'm selling it with the property, Maybe they're going to move it to their property in another town. If the purchaser is financing it as real estate, I have to convert that bill of sale that I have into a deed in order to convey it to that individual. So the reason I'm just kind of pausing here is because the kind of current statutory structure is really going to, the transfer, how you transfer the manufactured home is really dependent on how it's being financed by the person purchasing the home. If it's being financed as real estate, the statute is saying it has to be conveyed via a deed. And so the proposal here is to keep that current statutory structure in place, where if it's being transferred or financed via real estate, it has to be transferred via a deed.
Mr. Chairman, Mr. Vice Chair, I ask a question.
Representative Brannigan.
Cameron, I don't understand why the difference? What is the difference between these two titles of finance, these two, kinds of finance? And why are they important in this case?
Right. Probably a historical question that I may not be best to answer. At the end of the day, a manufactured home, they're previously mobile homes. Now they really are manufactured homes. I mean, that's what the federal term is used. And as we've talked about later on in the bill as it came out of the House General Committee and it's kept in here, there's some direction to our office to change throughout from mobile home to manufactured home. But, initially called mobile home because they are mobile. You can move them. And so, historically, they weren't financed in the same way that a stick-built home is as a real estate mortgage because, there's more risk to the financing lender because it's mobile and can be moved. And so that's my best articulation of why. Why are you treating them differently? Why have they been treated differently previously? Because that aspect, because historically, if you purchase it not as a real estate, you're not getting a deed. Deed, historically is about transfer of land itself. And so if you're not purchasing it via a mortgage or real estate transaction, you're purchasing it via some sort of, personal chattel property transaction. And because of that, it's not going to come with a deed. It comes with a bill of sale. Just like, if you purchase your car, for example.
We're going to hear from the Vermont Bankers Association a little bit about
Okay.
the options there. Yeah.
And so the challenge that we're running into, and my understanding, the challenge that the House General Committee was trying to address, and you all are looking at is, because of the nature of this type of housing, you have historically, you have these manufactured homes that don't have deeds. They have bills of sale. The owner may not be able to find that bill of sale. And then now, as I see the statutory, framework has been trying to shift in a direction of treating them more like, stick-built housing. And you all have determined in the past, if certain conditions are met, then we want to treat them that way and we want to transfer them that way via deeds. And so that's where you've seen the statute say, if it's going to be permanently sited on land that you own, we're not going to treat it as if it's this, movable property anymore. We're going to treat it as if it's a stick-built home. And we're going to require financial institutions to provide mortgages for that. And if we're going to do that, then we're going to move more into the universe of stick-built property, real estate, and we're going to require transfers of those via deed. So you've kind of seen the statute gravitating in that direction over time.
I think there are a lot of these things used. So we're talking about what we call double wide homes, right?
That is a version of them. Yes, ma'am.
I think we use a lot of them up in Franklin County. Farm housing, inexpensive housing. Thank you, that's helpful.
Representative Page.
So if we're treating it as a regular home, stick-built home, and even though it's mobile, there'd be certain requirements, just like buying a house. You would do a title search, I would assume, to see whether you would have clear, you know, title to this mobile structure if you purchased it.
Right, I believe so. A question probably best for your financial institutions and others that are in the room.
Yeah, if it wasn't permanently placed, I mean, it would be difficult, I would think, to perhaps do a title search.
And I don't, you know, I want to be careful. I don't want to give the wrong impression. And I don't think that I am, but just in case, you know, most of these are permanently sited. I mean, they're not moving, you know, once they've been purchased, once they've been, placed. Just keep in mind, you know, practically and legally, they can move. So, you know, as again, as I've seen kind of the current statutory framework, there is this shift of if they're being permanently sited, if they're being financed as real estate, then let's treat them as we do all other homes in Vermont, and let's transfer them via deed and move in that direction. The questions of, well, why do some of them have bills of sale? Why do we not require every financing via real estate? Why are we allowing there to be financing under kind of a personal property or a chattel property financing structure? It's because some of them do move. You know, someone could come into the state of Vermont, purchase a mobile home from a manufactured home dealer, and then move it out of state. And so you don't want to treat that as the same way you're treating other, you know, landed property in the state. So there are unique circumstances that kind of dictate or should have a separate type of treatment.
If it's on leased land, it's sometimes different, where they may own the structure but not own the land underneath, even though it's permanently affixed, and that's a different structure that has to be financed. Yeah.
I think
And again, that doesn't mean it,
Sorry.
that doesn't mean it can't be financed real estate. It's just not mandated by statute that it be financed as real estate.
Representative Maslin.
Yeah, thank you, Mr. Chair. When the bill was presented, I can't remember, if it was Brett Mahaly or someone else from that committee. It was pointed out that in the bill, you could, it seems unusual to me. You could sell one of these things with real estate. You could then transfer back to following certain provisions as a bill of sale. You could go back and forth. And I asked the question, but I was asking it to the wrong person in this committee room. Why go back and forth? And I sat with Brett Mahaly in the cafeteria a day or two after, and he acknowledged that it was unusual, but what he was always pointing out was that the committee was trying to do two things simultaneously, I think successfully. One is provide as much flexibility as possible for owners, transferees, but also create a statutory framework which I would describe as clean. We can understand it, it makes sense. Is that I'm conveying what I'm trying to say? So yeah, okay, fine. Initially I was hesitant, but I'd say, okay, good to go. This makes sense.
Yes, sir. Okay, jumping back in. As I mentioned in this section, so there are separate sections that are not in the bill because there's no amendments. And this is the same coming out of the House General Committee. When you look at the chapter that governs the transfer of ownership of manufactured homes, there is a section that talks about the bill of sale, what the bill of sale needs to include if you're transferring it via bill of sale. As I mentioned, there's a separate section that talks about if you're purchasing it and it's going on land that you own, shall be financed as real estate. If it's not on land you own, may be financed as real estate. Like I said, just kind of context to bringing you back to this amendment on page 2. Because as I said, the A and the B here, the current statutory framework is if it's being financed as real estate, it has to be conveyed via a deed. And so the rest of this section identifies what those deeds are. And so one of the amendments here on line 1 was a clarifying amendment that was in the House General recommendation as being kept here. So it's owner of a manufactured home shall, upon financing or refinancing or selling that has been financed as real estate or will be so financed by the grantee. So just kind of some recommended, statutory clarification there. Has to issue to the grantee either a warranty deed or a quitclaim deed drafted in substantially the form provided in subsection C or D. The amendments in these subsections are really just some very minor statutory cleanup. C is the warranty deed, D is the quitclaim deed, so they're adding language in there. This is keeping these kind of some of these cleanup language that was being proposed by the House General Committee. One thing that is a little different in this amendment versus what was proposed by the House General Committee is you are requiring in this amendment that the deeds themselves, if they're in substantially the form that's outlined in the section, then these legal consequences occur. And if you all recall, we had that conversation when I was initially doing the walkthrough of the bill. It doesn't require that the deed be in that form. It's just saying if it's substantially in that form, then here are the legal consequences that occur because of that.
Representative Holcomb.
Thank you. I really appreciate the work on this, and I'm a little thick, so I'm hoping you can take me through one more time. I think what I'm confused by is that we're calling these mobile homes. And to me, what they are is off-site construction. And I don't know why we're calling this a mobile home warranty deed, not a manufactured home or an off-site construction home deed. Because my fear, I actually think the reason we don't give them deeds is kind of maybe historical discrimination against more affordable housing.
Right.
And if these are homes, what unites them is the home, and it's
Right.
the mobility. I mean, we all, in all of our towns, I'm sure, have homes that were stick-built that were moved. I know I do. So I'm not sure.
Yeah.
And I know it's easier to move a home that is built off-site and designed to be moved, but it seems like it's a home.
Right.
So why are we calling it a mobile home? Because the primary intent isn't to be mobile. The primary intent is to provide a home. It just happens to be more portable than something built with bricks 200 years ago when we didn't have manufactured off-site construction, which I think is going to be our future.
100% agreed. And I think it was mentioned, I don't remember by who, it may have been the chair mentioned specifically that you can take a stick-built home and you can move them. 100% agreed. There is a section later on, and let me just jump to it. It was a proposal from the House General Committee, and it remains here,
Okay.
giving our office the ability to replace mobile home with manufactured home. They were initially called mobile, but in the 70s, the federal government took a lot of regulation and oversight over the manufacturing process of these, and they're referred to as manufactured homes at the federal level. And so they really should be referred to as manufactured here. One thing that in discussion with my legislative council counterparts, we felt that it was best to just continue to use mobile home currently in the language in the amendments, because we have this conforming revision authority. We want to make those changes throughout at once, as opposed to making some of them piecemeal. I've been trying to do my best to use the correct terminology of manufactured homes. Sometimes I'd say mobile home just because that's what the language on the page says, but.
But here we're passing a warranty deed that we know is going to have to be revised within a year, I guess, is the language of it, is my question. So if we already know that's where we're headed, why wouldn't we make those and then just let the rest of the conforming changes catch up?
We can, if that's what you all would like to do. My feedback to the sponsors of the bill and to the previous committee was there would be a lot of administrative and technical amendments if we did that. It's going to make your bill extensively longer. And then you run into a situation where for a period of time, at least, you could have, even in the same section, you could have manufactured home in this location and mobile home in the next section. And so our recommendation as an office was just leave it as it is for now. That way, when we go in and do those statutory revisions, we can do, a thorough top to bottom.
Can I ask one follow-up question? Because I don't know, this is not an area of my expertise, but my understanding, part of the challenge is ownership, and part of it is insurance. And is the mobile, is having that sort of residually there, is that going to impair the ability of these folks to get appropriate insurance for their homes?
That is a great question that I do not know the answer to either. And
No, well, I'm seeing a no.
and I was gonna say, maybe best, I know you have some financial institutions coming in, they may be able to answer that as part of their process of lending.
Thank you.
Okay. Okay, so back to these deeds. Again, this amendment is keeping the current structure, which is more designed to default to how is the individual who's purchasing the home, what is their financing mechanism of doing so? If it's going to be via deed, it has to be via a warranty or a quitclaim deed. And this amendment is keeping the requirement that it be in substantially the form that's provided. So we have the form here. One small change that was pointed out by the committee was this technical change here. The forms currently say wife, husband, so we've changed that to spouse. That was one of the recommendations. And so then we get to the bottom of this section, and here's where I will pause and jump back to Rep. Maslin, your point that you were bringing up. There was a provision that did allow an individual to sell a manufactured home via a bill of sale or a deed, regardless of how it had been financed previously. So a little bit to the flexibility conversation that you were having with Chair Mahoney. Current statute says if it's transferred via a deed, you can't go back and transfer it via bill of sale. If it gets transferred or is given a deed, then that's how it needs to be transferred moving forward. And so this is really a policy decision about how you want to treat these types of homes and whether you want that type of flexibility to allow people to go back and forth via deeds or bill of sale. I would comment just, kind of from a statutory construction and from, my perspective, I can understand that flexibility may be helpful, but it comes with its own challenges. If you're wanting to have kind of consistent documentation of transfer of ownership, I could see it becoming very challenging if you're going back and forth via deeds versus bill of sale. And it kind of goes a little bit against the grain of the current statutory framework in the direction the current statute is going. So there was a lot of testimony in the House General Committee, though, about the confusing nature of this. When do you transfer via bill of sale? When do you transfer via deed? But it's a policy decision for you all. This amendment would keep the current structure in place, which is more of a default for deeds if it's being financed as a real estate mortgage. Then we get into the section 2 around limited equity cooperatives.
Yeah.
Oh, yes, sir.
Can you just speak to, shifting the husband, wife to spouse? Like, is there a legal?
I just
We have to
mentioned.
use spouse as opposed to partner or et cetera, et cetera.
I asked one of my counterparts if spouse was the correct term. I said it's a model form, so I was concerned about, listing out, spouse, civil union partner, and getting potentially lengthy, just because it's a model form in the statute. The form doesn't have to say spouse, for example, and she recommended that spouse legally would be kind of all encompassing of the legal partnerships that we have in the state. So. Okay. Section 2, limited equity cooperatives, moving to the top of page 7, actually, excuse me, moving to page 8. There was minimal change in this amendment to this piece. If you all remember when we did the initial conversation about this, you have in the corporations title, you have a corporation type for cooperative housing. Within that, you have limited equity cooperatives, which are a housing corporation designed to be affordable to individuals of low and moderate income. And there are certain limitations on those limited equity cooperatives. And what this language here in sub 8 is about for a limited equity manufactured home community, about making a change regarding the leasing of those units. There's no change in that language from what was proposed by the House General Committee. So I'm going to move us to the sub B here. Bottom of page 8. This B1 has not changed. This is adding in language to say that for a manufactured home community that's organized as a limited equity cooperative, for state funding and grants purposes, it should be treated as if it were a state nonprofit corporation for a public purpose. This was intended to allow those entities easier access to state funds and grants, more for, think about like infrastructure, projects, et cetera. And what the addition, so the change is just adding this subdivision 2 on the top of page 9 to state that nothing in the subsection shall be interpreted to impact or alter the tax treatment of a manufactured home community organized as an LEC. So there was just discussion, if you remember, about, well, state funding, does that somehow impact the tax treatment of these entities? And you wanted to clarify, no changes there. So that's why we have the sub 2.
At a risk of calling out the tax department, I know that you asked them about this language, and I don't know if you heard back yet or if we should check back.
I have not.
Okay, great, okay. There's a lot of email that they have. Okay, great. I will check in with them about that. Thank you.
As I sat in the chair, I had not. I did
Okay.
just send it to them yesterday, so yeah.
I really meant, like, I'm not trying to call out the tax department. I was just wondering if I need to check in with them. Thank you.
Okay, so moving to page 9, I will say that there's no other amendments to the remaining sections of the bill. I'll just mention in section 4, if you all recall, this is about municipal zoning, and there was just some clarification language being added to the subdivision B to say that municipal bylaws cannot exclude these homes, manufactured homes, modular homes, off-site constructed homes, et cetera, from, and just clarifying that it's any districts that allow year-round residential development in the municipality. So that hasn't changed as it was proposed by the House General Committee. And then when we get to page 10, it really transitions the bill over into the sales tax versus property transfer tax, which is more John's area. So it may be, I'll pause there in case you have any questions on the sections that I've walked through. And Madam Chair, if you'd like, I can turn it over to John at that point, if it makes sense.
Representative Trump?
Can you just go back one more time on page 8
Yes, ma'am.
to the mobile home park organized as a limited equity cooperative, being eligible for the purposes of state funding and grants as if it were incorporated as a nonprofit.
Yes, ma'am.
Does that extend, is that to parallel other, for example, a state-funded permanently affordable village that has shared land? Is this designed to bring those communities in line with other existing communities? Is this what is the standard of care for VHCB funded projects?
To the second point, not to my knowledge. The committee discussed, if you all remember back when we had our initial conversation, you have these cooperative housing arrangements, and they're not by nature automatically registered as a nonprofit with the Secretary of State's office, because it's just a business organization type. And when you look at the limited equity cooperative, and when you look at the current statutory structure of it, there are limitations like this subdivision C here, or excuse me, subdivision 6, that limits what the kind of what the equity in the corporation can be used for if it ever dissolves. So this sub 6 is if the limited equity cooperative dissolves, any assets that remain after paying off its debts and paying the distribution to its members that's required can only be transferred to another nonprofit. So there's limitations on its use or its the value of what it owns. But they're not by default treated as nonprofits. And there's some historical issue at the Secretary of State's office where some of them are listed as nonprofits. And that appears to, from the testimony from the Secretary of State's office, be more of just a historical organization issue with how they, organize these business entities when they register. So some of them are designated as nonprofits in the Secretary of State, some are not. And there was conversation about if the statutory design of them is to serve low and moderate income individuals. And if you have these sort of statutory limitations on, what the property that the entities own, what they're able to do with it afterwards, similar to what you have with nonprofits. So we're kind of treating them as nonprofits. We're treating them as designed to serve low and moderate income people. It can be very difficult for some of them to access certain state grants and funds because they're not registered as nonprofits, all of them. They're not by default treated that way. So the committee asked, and I worked with the committee to try to come up with this language to signal for these entities, the manufactured home communities that are limited equity cooperatives, when they're going to access certain state funds or state grant opportunities, that they can point to this to say, hey, we are really designed like a nonprofit with a public purpose to try to alleviate the entity from having to jump through additional hoops or different burdens to access those funds. So that's the intent behind, or the design behind the language.
So I 100% support that intent, just to be really clear. My question is a little bit different. I mean, and it has to do with this cascading revision of language, because we're not actually talking about mobile homes. We're talking about off-site development manufactured homes that are people's homes, right?
Right.
And we may see more communities or villages organized with manufactured homes or off-site, and I hope we do, because it is more affordable. But there are also many communities that are currently supposed to be permanently affordable homes. The value or the resale value of their properties is similarly capped,
Right.
that they aren't considered mobile parks. And, I'm just,
Yes,
I'm wondering
yes.
why we aren't comprehensive, if the intent
Yes, ma'am.
is low and moderate income households, why isn't that the criteria as opposed to a manufactured home park?
Yes, ma'am. It is.
So I think that, you're welcome to answer, Cam, but I feel like that might be a better question for the House General Committee.
I was just going to answer a very small piece of it and then echo that. Yes, ma'am, exactly. I just wanted to agree with how you're reviewing the distinction. This only would apply, it doesn't even apply to all limited equity cooperatives. It's just the limited equity cooperatives that are manufactured home communities. And so, yeah, I think if you were wanting to have more of a comprehensive approach for these types of entities, that is a policy decision for you all. I'm just acknowledging your analysis of it. It is limited in that sense. And as to why not be broader, that's a question that I would defer to the committee itself.
I'll follow up. I just feel like this is really important work, and I think it's setting up a framework that is going to become used more broadly, probably. And so I guess I'll follow up with the community.
Yeah, I really appreciate that, and I agree. I think it's moving, we're making a decent number of amendments to this based on tax stuff. And so if it was a friendly amendment with that general committee, I'm happy to work on it. Yeah.
I know who to talk to.
Yeah. Representative Brannigan.
And backing up a little bit, I just want to clarify my own mind. We do have some homes that are built, they call them manufactured housing, but the frame of the house is built away at a factory. And they come in on a big 18-wheeler or a frame, and it's really impressive because they're assembled in like one day. but I think most of them are built on property owned by who is going to live in that house for the person. So are we saying earlier in the bill here, because that's land owned by the resident of the house, that they're treated like that, like a stick-built home. And then the other double wide that I referred to a while ago that are, more moved in one piece. They're different, and that's what we're addressing in the bill mainly, but not the first kind of housing I talked about. Some of those houses are beautiful. I mean, 4 or 5 bedrooms, several bathrooms. They're huge.
Yeah, that's actually part of what I was asking my questions here, because these could be very high-end communities.
Yes, they could. Yeah.
It is,
But
it is
the
a,
land that
yeah.
makes a difference?
it's a question really about just terminology and so, you have, manufactured home, modular home, prefabbed home, offsite constructed home. I've heard all of these different, kind of words thrown around. I don't know that there is a universal, I don't even know that there is a specific statutory definition of what an offsite constructed home is. Because an offsite constructed home could be what is historically a mobile home. That it is built offsite. But it could also be these more, modular homes that I think you're referring to, as you mentioned, kind of brought in 18-wheeler and then the pieces are constructed on site. This bill is only impacting what has historically been a mobile home. And so that's why I've just pulled up this definition, because both the initial section about the transfer of the ownership via bill of sale, via deed, is it financed via real estate, etc. All of that is tied back to this definition of a mobile home, which, as I mentioned, is at the federal level, they're now called manufactured homes, which is why we've asked for that revision. I shouldn't say we've asked, you've included that revision authority to have us transfer the name of mobile home to manufactured home. When I'm legally referring to a manufactured home, it is the historical built on a chassis, meeting certain definitions under Fed regulations. So the more mobile home historically, that's what I'm referring to about manufactured. And it may be worth the conversation, for you all as a legislative body to begin to distinguish those things in statute. So we all know what we're talking about when we say manufactured. Are we just talking about the historical mobile homes? Are we talking about all offsite constructed housing? So anyway, I'm just saying that I know there's a difference in terminology that's kind of used, somewhat casually. This bill is only dealing with historically mobile homes.
Yeah, and then I want us to make sure we have time for.
This may not be for you again, but I go back to, as a lister in our Microsoft program, we actually have a mobile home category.
Right.
That's, length, width, the skirting, you name it. Is there any implications for that process or that category to be concerned about, or?
I don't think so. Not in the bill. No, sir. No. What it would do is if this were to pass in the amendment that's proposed in its current form, it gives us the statutory revision to change it. So in statute, you might see changes from mobile to manufactured, in which case, it may be appropriate for that software to be updated to reflect that change, but the statute wouldn't mandate it in that sense.
Okay, thanks.
Yes, sir.
Thank you so much. He didn't make any changes to the John section, so he's just gonna stay there in case we have questions.
Except the last section.
Oh,
Section 12.
Yeah. Do you want me to?
is that the study?
Yes, ma'am.
Okay, will you just?
Yeah.
I feel like I could explain that. Or
Okay.
you can explain it. I don't know if people need to change chairs for that.
Give me one second.
While you're pulling it up, I'll just say, so there was a study in here about how these cooperatives are appraised And since we have a whole other bill that's focused on consistent appraisal, working on language to move a sort of more directed portion of that into the regional assessment district bill instead of having it here. So we're not creating a whole new project for property valuation review, but in fact, just asking them to do this as part of all the other work they're doing.
I think that's a great summation, as opposed to me, waiting to kind of pull it up. There was, so, what I will say is, in this amendment, you do add that B2 that I mentioned, where it's saying that by treating manufactured home community limited equity cooperatives as if they're a nonprofit for a public purpose, you're not intending to alter the tax treatments. There was concern in the House General Committee about how limited equity cooperative manufactured home communities are being appraised and concerned about the consistency of their appraisal throughout the state. So there was a report from the tax department to investigate that and come back to you all with information. And as the chair mentioned, that report itself has been removed from the amendment with intention of moving some pieces of that elsewhere.
Where does that show up here, Kim?
It's not in the amendment because the section was struck. I am trying to pull up the bill as it came out of House General, so I could reflect that quickly. Give me 1 second and I will be able to pull it up.
We will live in a different vehicle. A mobile vehicle.
Yeah, there were so many opportunities there. Thank you.
I apologize for opening the door.
Okay.
Yeah.
This is the report that was in the recommended amendment from the House General and Housing Committee. So on or before November 15th of this year, tax department shall submit the report looking at the 1, 2, 3 there on lines 10 through 13. Different appraisal methods across the state, if there are any, an examination of any jurisdictions for differences in approach. And then I think the key piece is the sub 3 recommendations for ensuring consistent and appropriate appraisal, taking into consideration the limitations under 11 VSA 1598. So what the 1598 is, that's the limitation I mentioned earlier in the section where the limited equity cooperative, if it dissolves, it can't, it has to transfer any of its remaining assets to another nonprofit or to another limited equity cooperative. So kind of, limiting the value of the entity if it ever were to transfer ownership. And so there was concern and discussion in the committee about these entities being somewhat appraised and treated differently throughout the state based on those limitations. And so that's where the information here came from, to have this information come back to you all to make a better informed decision about whether there needs to be changes in statute regarding that. And so this is the piece that was just, Mr. Vice Chair, to your question, it was just removed. And so with intention of having it live elsewhere.
Thanks.
You're welcome.
So I know that one of the real sort of core focuses of the House General Committee was to make sure that that they are enabling the purchase of these homes as much as, to the greatest extent possible. And since we made some changes, we're making some changes to the tax treatment, wanted to make sure that we are not making it harder to finance any of this. So we asked 2 folks from lending institutions to come join us. Rachel McLeod, did I get that? Yes. Great, thanks for joining us.
Everyone, I'm Rachel McLeod. I work with East Rise Credit Union. I'm in the mortgage department. I've been there for over 20 years. And gosh, where to begin? We finance manufactured homes on owned land, also on leased land and, parks cooperatives. We finance them all as real estate. When
Do Deeds.
Yeah, yes, with deeds. Probably maybe a little backstory in terms of why we landed on real estate well, and actually, when I think of this bill, I think of the ones in parks and co-ops, right? Because those seem to be the most challenging to finance. We kind of went through a journey the last couple of years in that. I worked for New England Federal Credit Union that recently merged with Vermont State Employees Credit Union. And Vermont State Employees Credit Union has been financing manufactured homes and parks and co-ops for quite some time. When we merged, we wanted to continue that. And in looking at the existing process, they were financing them as personal property. You know, our mortgage department, we're used to doing mortgages, right, for the most part, and we have processes in place regardless of the type of home or product. And so we started digging into how could we also treat these as real estate? And there's a variety of reasons why that felt like a goal for us. You know, our individual journey was just, you know, for instance, personal property loans. We had a mortgage loan origination software and document provider that didn't really support personal property loans. There's, you know, TILA RESPA guidelines, federal guidelines we have to abide by, and they kind of speak to, you know, I don't know, you may or may not be familiar, but there's a loan estimate, there's a closing disclosure, there's these important disclosures that a mortgage lender has to disclose that TILA RESPA more or less says are not appropriate for chattel loans. And so it was going back to using disclosures pre-2015 called the GFE, or the good faith estimate, the HUD, the TIL, the truth in lending disclosure, that I personally knew how to do because I've been in the, you know, in mortgages for years, but most of our staff had never touched those. So just between those considerations, we started looking toward a way that we could do them as real estate. You know, many challenges, including we found a lot of these home buyers were coming in the door with their purchase and sales agreement and a bill of sale. And we were saying we'd have to redirect and say, actually, we need a warranty deed. And so, you know, if I go back to the February 5th version of this proposed bill, we were happy with it in that, you know, it would have made it possible to finance them, whether they were conveyed via bill of sale or warranty deed. Before this proposed bill even came about, the current statute says if you're financing them as real estate, you have to have the warranty deed. And again, a lot of these sellers were offering up a bill of sale. So that's been tricky. And, you know, on the buyer side, as a mortgage lender, we're not talking to the seller, right? There has to be that space in between. So redirecting, it's, you know, getting your realtors and your attorneys together to have that discussion of Eastrise only finances these as warrant or as real estate. And then I guess the other thing is, you know, we found that a lot of our attorneys didn't know the warranty deed, the mobile home warranty deed model form existed. Nobody's really using it in my experience. And so while, you know, it's not bad to have it out there, I liked how we made the change, or they made the change to make it a may use. Most sellers, attorneys, stakeholders in the transaction are just using a standard warranty deed, you know, the same warranty deed you would for any transaction. I think another caveat of that mobile home warranty deed is that it has a place for the landlord to sign off on it, and chasing down a landlord just before closing is difficult and can delay closings. And if you think about leased land, there's usually a lease in place. And that landlord's not usually signing the lease until closer to closing anyway. That's almost like their approval of that borrower, that renter. And then just, we as a lender, and I think a lot of lenders are having a landlord earlier in the loan process sign kind of like a park approval form. So they're signing off and giving approval anyway for this transaction to happen. And then kind of fast forward, so the bill of sale conversion, you know, when we started doing these as real estate, we would have a refinance come in the door. And technically, if they financed with a bill of sale, we had to convert it to a warranty deed to be able to go forward with the refinance, right? And it's just, that was an interesting journey, and that we have legal counsel that's helped us all the way through all of this. And town clerks had no idea what a bill of sale conversion was. Like, many of them had never even dealt with it before. So then I guess the other thing is when we were working on this process and rolling it out, we have about 45 attorneys statewide that we work with on our approved attorney list. And a lot of them weren't aware of the bill of sale conversion either. So I guess we're just, you know, if nobody's doing it, I know that's not the right answer to stop doing it just because nobody's doing it, but you know, if we were hoping there could be a way to allow, you know, it to be interchangeable, that you can use a bill of sale or a warranty deed to finance these as real estate or personal property, and then not have to worry about the bill of sale conversion requirement. I think the other concern with that too is if Eastrise finances them as real estate, down the road, they want to refinance with another lender who might have better terms, whatever, and that lender only does them as personal property, you can't convert back, can't go backwards to a bill of sale. So that could be a negative impact on that borrower as well.
Can I ask you a question about that? Yeah, so basically like everything we've been doing in the tax code around property the last few years has been to create consistency when possible, because there is so much inconsistency. And a lot of folks at the municipal level don't know necessarily, like aren't speaking the same language as someone in the next town over.
Yeah.
And that creates a lot of unfairness, right? From like for Vermonters who are paying their taxes. And when we look at favorable, like we want to create a favorable sales tax or property transfer tax, right? In order to do that, we want to have consistent taxation of all of these properties. It's very weird, my technical term, to apply a property transfer tax to something that is not real property, right? And so like, if we're going to put exceptions in this, we want to find as narrow a path to those exceptions as possible while still not interfering in financing, right? Like the reason that we're not just entirely moving to deeds is because of financing.
Could your definition though be the fact that they're permanently sited? Like, could that be where the focus is? So, I mean, we as a lender are making sure they're permanently sited because we also have to, if we're treating it as real estate, we're trying to meet the TILA-RESPA guidelines that say it only applies to the permanently sited. That's where we kind of picked apart that definition of the permanently sited. We were like, all right, one or all of these can apply. And that makes us able to finance as real estate as well. That was another consideration.
That's helpful.
Just a thought.
No, that's a really helpful thought. And we're like trying to find a path forward on this to like create both consistency and opportunities. And that's really hard. That's why the bill was created, right?
Yeah, and I think just from my perspective, while we treat them as real estate, we also know there's many lenders out there doing them as personal property. And so where I get a little concerned is just we don't want to close the options by any means. You know, for us, it's a personal or a portfolio product. We keep these in-house and we have a balance sheet to uphold. So while if you ask me, I would do these loans all day, every day. We don't want to say no to anyone, but you know, it's a popular loan product. And so that, you know, we can only finance so many of them in a year. We have to budget. So that's a thought too.
Thank you. Could you say a little bit more about a portfolio product? I mean, I understand
Yeah.
what you meant, but I'd like to
Yeah,
hear
yeah.
you in your language. Why
So-
you do that?
We sell loans on the secondary market, so to Freddie Mac, Fannie Mae, there's Federal Home Loan Bank of Boston. So we have different investors that we sell to. At this point, we are unable to sell them to any of them. The ones in parks are cooperatives.
Right.
There is a pilot program out there with Fannie Mae, where they're trying to work with states to finance them only in cooperatives. There are a lot of challenges to work through there, and we haven't been able to get through those challenges. So,
Follow-up question, if I'm going too far, we can back up.
No, this is.
So, this makes sense. It opens a different window into your, how you guys work. And I appreciate your efforts to trying to, I guess we could say thread a needle or something to that effect, to make more options available for people with such dwellings, shall we say. And I don't know if this is a question or what, but I'm just making a statement. I appreciate that. This is a new window for us, at least for me anyway, trying to figure out how you guys work. And what you're saying is consistent with the conversation that I had with Rep. McCauley several days ago on trying to create flexibility for owners and sellers. And I appreciate understanding a little more about it. That's all. Thank you.
problem.
I might have interrupted your testimony. I don't know if there was more you wanted to say.
I don't think so. Happy to answer questions.
Anyone else have a question? Yes.
Yeah, we do have a section in the bill. There was a section in the bill about describing as permanently cited. And one or more, you used to say just include, but specifying, trying to be more, I guess, expressive as saying one or more of the following has been set up on blocks or otherwise stabilized, mobile homes been connected to utilities, skirting's been installed, all wheel racks have been removed, and the mobile homes been situated in a place that makes removal unlikely. So thinking about that, is that fulfilling your need for what permanently cited means? Or are you saying that permanently cited should be the determinant for a warranty deed versus sale?
So I guess there's even many considerations surrounding that. We very much wanted to finance these as real estate for some of the challenges, for the reasons I mentioned before. And so in picking apart that section, we also knew that a lot of times in parks and cooperatives, I think the newer homes you tend to see placed on a concrete pad and all the tie downs and the wheels and hitch might be removed, things like that. But our experience had been a lot of them don't have wheels, hitch removed, the tie downs, that sort of thing. And so we decided going into it, it was one of those things where we're like, are we going to finance these? Or are we going to finance these, right? We don't want to deny everyone that comes through because of that. So we looked at that requirement and said, what's the minimum we can accept to still consider these personal or real estate permanently cited, and took it from there. Now, this only applies to our portfolio product, right? So if it's a manufactured home on owned land, in a perfect world, we're selling those on the secondary market. And they have much stricter guidelines. But typically on owned land, they do kind of have all those parameters in place, you know, the wheels and hitch remove, that sort of thing. So
I heard your answer and I heard your question and I'm.
I answer it.
The language that we have, it works for you if you're asking for a change in it.
no, I'm good with it. In
Okay,
fact,
great.
Yeah.
Okay.
The fact that it says one or more of the following.
Okay, thank you.
Great.
Okay, great. Okay. Sorry, you probably did understand. Okay, thank you so much for your time. Really appreciate it.
Yeah, no problem.
And I have to say, I love a Reg C truth and lending disclosure. Those are awesome.
Are you an expert in those?
Oh, just a covering banker.
Okay, I appreciate that.
Chris, do you want to join us? Or will you join us, whether you want to or not? Thank you.
Happy to join.
Thank you.
Good morning. For the record, Chris Delia, President, Vermont Bankers Association. Thank you for the opportunity to come in and testify. So I'll give you a broader perspective than just the financing as real estate. So I'll kind of put it into three different categories, if you will. Person owns the land, buys the mobile unit, it's wheeled up, it's permanently fixed to the land, et cetera, et cetera. That is treated as real estate. In a cooperative park, where there's an ownership stake that the individuals have within that park, I have some that will treat it as real estate, and I have others that will treat it as personal property. Those are business model decisions that they've made. And then the final one is when you've got a leasehold park, and there is no ownership stake. Those will be, for the majority of my lenders, treated as personal property. So you'll get a bill of sale, you'll get a UCC filing in the land records and in the Secretary of State's office. When we met with Representative Pezzo and Mahaly in the fall, our goal was to maintain as much flexibility as possible for the borrowers in the marketplace. Because as soon as you say we're going to treat it as real estate and everyone treat it as real estate, you will have lenders vacate the market because that's not their business model. And I don't think that's what you want to have happen, because you want those lenders in the market because this is very viable housing for a lot of people out there. So it's ownership structure that matters. It's siting on the property, permanently fixed, et cetera, that matters in the decision making. You heard a little bit about portfolio or selling in the secondary market. But from our perspective, we wanted to make sure there was as much flexibility as possible for the borrowers that are out there in the marketplace.
And just to put a fine point on it, you're saying that if we moved entirely to a deed system, there would be folks who could not borrow or are borrowing.
Your pool of lenders will shrink. You'll have fewer lenders in the marketplace because that is not their business model.
We have fewer lenders in the marketplace and still the same loans going out?
That all depends on their appetite. I would doubt it.
Okay, thank you. Any other questions for Chris?
So in the example of someone purchasing an existing manufactured home from someone else from property, sorry, this is maybe too complicated. You own a permanently sited manufactured home on your land and you want to sell it because you're going to bring in a new unit or you're going to build something, whatever.
Sure.
I buy it from you.
Sure.
So do I get a warranty deed from you for that, or do I get a bill of sale if I take it from you and then put it on land that I'm going to rent?
Land that you're going to rent. I do not have the information to answer that question.
Yeah.
I don't have that, but that's a great question.
Will you get the information?
I will try and do that unless your counsel has that information.
Who has the book?
Is it a green book?
Different book.
Okay.
Chairman of the council, the way I would answer it is it's going to depend on how you, as the purchaser, are financing it. It's going to depend on whether it has previously been financed as real estate, because there's a statutory section that says if it has a deed. So in this instance, it was originally financed as real estate, so there's a deed for it. Now it has to remain a deed. So even if you're putting it on land that you lease, you're getting the deed. You're not going backwards to bill of sale. If it is originally financed as a bill of sale and you're purchasing it and you're going to put it on land that you lease, but you've gone to East Rise and you've got a mortgage for it, it has to be converted to a deed and then transferred to you. So it's really dependent on has it been given a deed previously? Because if so, it doesn't go backwards. And then how are you as the purchaser financing? That is how the statutory structure is currently framed in law.
So then your challenge is to find a lender who's going to finance it under that scenario. Thank you.
To take on leased property.
Can you give us a ballpark estimate? How much is that going to cost the purchaser to transfer to a deed?
Oh, boy, you're getting into closing costs on legal fees, et cetera. A few $1,000s perhaps.
Any other questions for Chris?
Oh, and good luck on the tax policy implications if there are any for you here. Because that is a challenge.
Thank you. Appreciate that.
Oh, you know,
Kind of you.
I'm sure you'll come up with the right answers.
Yes.
I'm just curious. I mean, Vermont is not unique. I mean, there are other states that, have manufactured homes. How do they do it? I mean,
Well, I don't know what their statutory structures are, but I can envision where you have models that are similar to ours, models from a bank, from a lending perspective, that are similar to ours, where you would treat it as real estate or you're going to treat it as personal property. And then again, you're going to be looking at if you're doing it in portfolio. And I'm following one set of guidelines over here. If I'm going to be selling in the secondary market, then I'm going to be underwriting it to those guidelines. With regard to the real estate transaction or financing aspect of it. So, yeah, we're not unique. And I think what you're trying to do here is to create, again, some greater flexibility and looking at this as a public policy goal, that these are viable housing units that many Vermonters can look to today. The units that are being sold on the market today are vastly different than what they were 10, 15, 20 years ago. They are much better units that are being manufactured today.
So as we're sort of moving to units that depreciate much slower, do you see the lending opportunities opening up and shifting?
Well, I think the lenders.
Sorry, I'm gonna add a second part to my question.
Okay, so,
Yeah. Or is sort of the essential, like where it sits at the end of the day, the deciding factor for lenders? Like, private land, et cetera.
Okay. I would say that it's both. The units that are being built today, again, are much better in quality than what we had years ago. So there's a more like-to-like comparison to a stick-built home, in my opinion. The units that were built many years ago would not be at that level for many different reasons. So I think you're seeing a better quality product that you're able to finance in the marketplace. So there's less risk, if you will, from the lender's perspective. And then what's the risk associated with it? Well, if it's permanently fixed on a piece of property, tied down, et cetera, there's, say, less risk for some of our lenders. Do we see a lot of mobile homes being moved in the middle of the night on our highways in Vermont? No. But there is the notion that if it's in a leasehold park, I can slap the wheels back on, pull the skirting off, disconnect it, and I can move it somewhere else. Are there risks associated with that? Some lenders say, yes, the risks are a little bit higher. So that's the way they look at those types of situations. Each circumstance unique to the borrower. But the quality, again, is much better. So the risk of deterioration is less than what we had for homes that were in the 70s or 80s, perhaps.
Chris, does the current version of the bill give you the flexibility for your lenders that you need?
Yes.
Thank you.
Thank you.
Do folks need more time on this bill? Representative Maslin.
I do not. I think we've gone through it fairly carefully. I don't have one unanswered question at this time, and will compliment the drafters and the questions around the room too.
And Representative Holcomb, you want to work on some language? Could you,
I can, I'm gonna speak this, but.
okay,
Someone came with it first.
okay, so if you could let me know this afternoon and we could maybe find time tomorrow for it.
Right.
Okay, great, okay. Is anyone else gonna need anything before we would move to a vote?
I'm all set.
Okay, great. Thank you, everyone. Did you? Okay, great. So we are gonna take a break until 10:30. Is it too late for me to tell you that?
It's not too.
Okay, great. Great, we're gonna take a break until 10:30, at which point we're gonna. Are we doing 5:58 or 5:49 at 10:30? We're great. When we get back at 10:30, we're gonna do something.